All right, Judge, next is page 24, Simon.
Oh.
Good morning, Mr. Simon. Good morning. Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. Car,
Sorry.
is it driving in a car?
Yes,
And does he have a license to drive?
driver's license right now, Your Honor.
Okay. Mr. Simon, as a condition of your bond, I'm ordering you not to be in possession of any weapons while this case is open. You are not allowed to drive unless you have a valid Texas driver license and a liability insurance in your name. If you do not have either, then you are not allowed to drive, and that is a condition of your bond. Do you understand? I'm just asking you to follow the law. Do not have any weapons, otherwise I will revoke your bond, put you in jail. No more PR bonds for you.
His license is eligible.
Great. Do you have the ability to hire a lawyer, sir?
Yes.
We will give you time. There's a gajillion and one lawyers in Harris County. 99% of them will put you on a payment plan. If you ask for a couple $100 a month, they'll represent you. It's like buying a car. Don't go to a Ferrari dealership unless you can afford it. You know what I mean? Same thing with a lawyer. There's the Cadillac, there's the Ferrari, there's a Yugo, there's a Hyundai, whatever it may be. All right. We're going to reset your case, give you time to hire a lawyer. I'm going to have you take a seat in the jury box. Once you sign the bond conditions, at that point, you'll be free to go. Please. Okay. State's bond today.
Oh, yes.
Hi, Joe.
Hey, good morning.
Judge, that's it for now.
Okay.
All right, go ahead and have this in the jury box. I thought it was- yes. I want to. All right, one out is April 9th. All right.
Which one do you want? This one?
Yeah.
I got you.
Yeah.
All right. I'm gonna be- and there's a need to be done right. Oh, I don't think I'm doing it. I'll look around. When it's not before recess, that's when it comes to the process. And we put it against. And then now. I'm trying to see. I saw one of those. Alright, so I stated that they were open tonight. So how's it?
What are those?
Gord?
Yeah.
Hey.
There's
Okay. Yeah. Yeah.
They have to celebrate that. Like, it should have. That's
Yeah, 14.
No, that's an act. No, yes. And I heard it, oh, that's almost. Yeah. Because.
All over the I know very little. She only had the top of the market. She only had Yes, there's
Yeah.
Let me look at it right now. Yeah, I think so. Sure. So, with a political set of reading, yes, fair enough. Yes, sir. Underground.
Yeah. Hey, good morning.
Yeah. They don't do Well, they'll do.
Or how about just
That's right.
So, since they say that they don't want to do this,
Oh, they don't.
if you want to do
One section.
Only the first time that we already walked in.
Y'all got a good system there, they say. She cooked my cake on.
They did it.
Thank you, thank you. I know.
That's great.
It'll be a she's a parent. Because you want Oh, Council for reset.
Yeah, see you, Porter. Sorry to keep you waiting, Mr. Clay. Are you ready? Come on up. Just the last name of your client. In jail or on bond?
It's just a motion to shove subjects into the queue.
It's a motion for what?
Subject just being the contract.
Okay, that one's on the intention.
I don't see anything in the queue. Say it again?
I'm looking.
Okay.
The motion to cut. Review it, right?
Yes.
Get it, and then we got all set yesterday.
Are you here for Mr. Leonard?
Oh, no, Felix Cruz.
Yeah, I know, but are you here for Mr. Leonard?
Oh, yes, I'm subbing in on the case.
Yeah. I'm looking at it.
Oh, he's got it. Done.
Thanks, Judge.
Thanks.
Have a wonderful day.
You too. Take care.
Good morning, Judge.
Hi, Mr. Haggard, how are you? Good to see you, man. What's new?
Judge, I'm here on Mr. Safari, SAFFARI,
Okay,
and I was speaking to.
oh,
We need a probable cause,
do you want to?
not really, Judge.
Okay.
He was doing 100 miles an hour, 120 miles an hour.
Yeah, 122 and that's 60.
122 miles an hour?
Yes.
Mr. Safari, come up. I'm not letting Mr. Haggard, he's not, no,
Well,
no. I'm sorry. Go ahead, and if you don't mind, Mr. Safari, we are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. Okay,
On March 14th, 2026, in Harris County, Texas, officer observed a vehicle going 70 miles per hour on Katy Freeway. Officer accelerated their speed to about 110 miles per hour, and defendant continued to accelerate his speed and make multiple lane changes without signaling and weaving through traffic. Defendant reached a max speed of 122 in a 65-mile-per-hour zone. The driver of the vehicle was identified as defendant. The officer observed glossy eyes and a mild odor of alcoholic beverage emitting from his breath. Defendant admitted to drinking one shot known as a B52 45 minutes before the traffic stop. Standard field sobriety tests were conducted, 4 out of 6 HGN, 8 out of 8 walking turns, and 3 out of 4 one-leg stand. BIC was read and a sample was denied. A blood search warrant was executed.
any prior DWIs?
And no prior DWIs, Your Honor.
Okay, Mr. Safari, I'm going to find that there's probable cause to go forward with your case. I am now taking your ability to drive away from you. You are not allowed to drive at all. You will sign with me an affidavit. This is a promise that you're going to make to me today that you're not going to drive. If you do, I can have a contempt hearing, and every time you drive, you can be facing 180 days in jail and a $500 fine. Do you understand?
Yes, sir.
Do not drive. I don't care what you have to do in this life. You do, you will go to jail. As a condition of your bond, you were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. If you fail to go test, a warrant issues. If you consume alcohol or illegal drugs, likewise, a warrant issues. Do you understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with him. If he tells me he cannot get a hold of you because you're playing games, likewise, I will revoke your bond. There are no more PR bonds for you. This is not a revolving door. If I have to put you in jail, I'm going to make your bond high. For now, I'll have you go to Victoria, sign a reset. You'll get with Veronica for your bond conditions, and then we'll have you come up here, swear to us that you're not going to drive.
Sir, thank you, Judge. You understand why when you ask me, the way probable cause.
Yeah, I get it, but at 122 miles an hour in a 65,
Hopefully do better on the direct, on the blood test. Let's see, we'll test the drink.
do not drive. I'm not going to warn you again.
We get to get somebody, you gotta get your car, it's not get you.
Counsel.
Get so much. All
right, come on.
Thank you, Judge.
Thanks.
So good, so.
He has to go over there and put him on that.
Yeah, no, I have to.
Administrative information. You swear to firm not operate and motivated in the balance of your act. There's something without no.
Hey, please,
Why don't you want Docket,
just the last name, please.
yes, Razzo and Jones.
This way.
Okay,
They're both in the same situation where they technically completed the contents of their PCI, they just need to pay $30 fee. To complete it, so if we could just get one more reset so that they can get the check into the DA's office.
how long? I mean, they're at 170 days old. How long do you want?
I mean, if we just get a regular fee, whatever your honor wants, 2 weeks. 30
2 weeks
days.
is it, but after 2 weeks, let them know if they don't have it done by then, because they've had since February, and if they don't have it then, I'm gonna roll them day for day if they get it,
Yes.
right? Okay,
Thank you.
yes, ma'am.
The next one. Council for recess. Council for recess. Can I give you the case number when you're ready? Simon. Simon, you can help me out.
Perfect.
All of the signatures.
Well, yes, sir.
Right. You open it, so
That's an arraignment when you're ready.
Okay, give me a second.
Oh, you are. You can cross. Oh, okay. Wait, hold on.
Sorry.
All right, Josh, top of page two. On that.
Hey, can I borrow you, one of you guys? Anderson's the last name.
It's also.
Mr. Anderson, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. As a condition of your bond, I'm ordering you not to have any contact with the complaining witness in this case. There's a protective order that has been issued and you need to get to know it. If you do something to violate this protective order, they will file additional charges against you, a violation of a protective order, and that is one of the worst misdemeanors that you can pick up. Do you understand? You're not to have any contact with this person whatsoever. I don't care if she calls you. If she calls you, hang up. If she texts you, do not reply. If she comes to your house, don't answer the door. You're the one that's going to go to jail, and this is not a revolving door. You will not get PR bond after PR bond. Do you understand? How old are you, sir? How do you support yourself? Okay. It is time for you to get a job. J-O-B. I am now making that a condition. You don't get to just sit at home and do nothing all day while everybody else is paying for you. You need to get a job, to do something with your time, because otherwise life tends to get self-destructive. You hang out with the wrong people, you pick up new cases. You are now 19 and on number 1, 2, 3. No more. Do you understand? So appointment a lawyer, please, and then back in 2 weeks for a job.
Yes.
When you come back in 2 weeks, I want to see 20 to 30 applications filled out, and I want proof, not spoken word. Do you understand me? If you haven't done anything, it's not going to go well between us. No contact, no weapons.
Thank you, Judge. We'll get him squared away.
Thanks.
Council for recess. Judge, I have a case number whenever you're ready.
Okay. You just get this turn. Okay.
Case number is 2596828. She failed to appear on her arraignment studies.
Okay. I'll bring you up here momentarily. Did you see
You signed the CPR, the date is the 23rd, which was Monday. I'm not sure if I changed that.
I meant to put the 31st.
Okay, it's in the queue. It's waiting for activities.
Sorry, okay. Thank you for checking. Don't talk. Yeah, it's supposed to be the 30th. Thanks for, yeah, I got it. It's done. Thanks. Hey, Dane, how are you, man? Hey.
Hi. So I have a client that's 173 days old. He's gonna be in PEI. He came back low risk on T-res. I've asked the probation department to reassess what they're asking to do, even though it's the lowest possible risk. This is the standard thing that I'm getting a lot. They're requiring classes, frankly, that are unnecessary based upon my training. So I asked the head of probation to look at the T-res. That's where I'm at.
Okay. So how long is that gonna take?
I sent it to her yesterday because that's the first time I got the T-res was yesterday.
Okay. And I mean, in the interim, you can start working on getting everything though.
He's done everything else. He's actually here to pay his fee today. He's gonna go pay his fee today.
Does he have the interlock already?
I don't think he has the interlock in because they don't know exactly what the conditions are.
Well, the interlock's standard on everyone regardless, right? So
You
at
gotta
least,
pay for it as soon as you install it. So.
I mean, it's not gonna be too long. I mean, it's
No,
only a week or so.
He's
So-
taking care of stuff today, for sure.
So let's set it off till next week. I mean, I can't imagine it'll take that long to
No, and if I can get it done in the interim, I'll have.
Okay. go for it.
Okay, thanks.
All right. Ms. D,
No last go, Judge, for plea.
okay.
No last.
Come up, Mr. Nolasco.
He's in custody.
Oh, he's in custody.
Bring it
Got it.
out. Yes, sir.
Alright, so next week, which day would you like?
It's far out. It's possible.
Thursday, our, second? Sure. How long is that for? Very good.
Epimenia,
Yes, sir.
what you got, man?
It's a medical bond condition. It's off the judge.
What's your cause number?
259,
Okay,
8616. Jefferson or Solid.
okay,
I approached last week, Judge, asking to get a CPS and I was granted. The reason for that was he was going to work now and then his father as a father. But I failed to address, well, it's random, so they check.
yeah, I mean, I'm not gonna take that off.
Oh, but is there a way that we can have them take it in Alabama?
He'll have to go to a Quest diagnostic. It's gotta be Quest. It will not accept anywhere else. Okay? So, and it's up to, if he gets called, it's on you guys to get the drug test, get it back to us. Otherwise, I'm gonna haul him in here. It's not gonna go well. So let him know that if he gets called to take a drug test, gotta be at a Quest. And then it's up to him to get it to you, get it to us ASAP. And then if not, then a BVR gets filed. Okay? All right, you waive the signature.
Thank you.
All All right, Mr. Nolasco, you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 24 days in jail with credit for the 8 days that you've done. You need to understand that this charge will go on your record. It will be there forever. Any new cases from now on, you're facing a minimum of 90 days in jail. Do you understand?
Yes, Your Honor.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, you can never change this or undo this.
Yes, Your Honor.
Is this what you want to do?
Yes, Your Honor.
How do you plead to the offense, guilty or not guilty?
Guilty.
I'm going to find you guilty. Follow this agreement. I am going to suspend your license for 180 days. Do not drive until you get a license.
Yes,
Good luck, sir.
Thank you, Your Honor.
Thank you, Mr.
Yes,
Dean.
sir.
Hey.
Judge?
Yeah.
Judge?
Hey, I'll try in a second. All right, good morning, Mr. Sanders. Sir, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 12 days in jail with credit for the 4 days that you've done. This charge will go on your record. It will be there forever. Is this number 1, 2? Do you know?
Number 2.
What happens on the next theft, Mr. Sanders? Wrong. Prison. You were looking at years in prison, not just a rinky-dink 12 days in jail. A third offense is a felony offense. Do you understand? You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, it will go on your record. It will be there forever. Is this what you want to do? How do you plead to the offense? Are guilty or not guilty? And we'll find you guilty, sentence you to this agreement. Good luck to you, sir.
Thank you.
Thank you, Mr.
Step over here.
Hey. What's up? Oh, I'll try. How many do we need? Okay, bye.
So I don't want to remain workers all over the place. And that's what very correct. There's to tell them. So yes, that comes in.
Morning, Your Honor, Mayor Bush.
Yeah.
Lieutenant Tomas Espina for an arraignment.
What's the last name?
Espina.
Do you have a cause number?
Yes, sir. 261.
Got it. Okay. Thank you. Lubos, come up.
With this one, Your Honor, he's accused of assaulting a maintenance worker that works across the street, but also goes to his property area. I'm gonna ask for no threatening, harassing conduct, so he doesn't have to move out of his home.
We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
On March 18th, 2026, in Harris County, Texas, officer was dispatched to a business building in reference to an assault. The security guard, the witness, stated that one of the maintenance workers got assaulted earlier in the day. Complainant stated he was blowing leaves off the entrance to the parking garage when he saw the defendant coming towards him. The defendant pushed him from behind. The complainant fell forward and hit his face on the curb of the parking garage, causing a cut on the left side of his knee. The defendant said something about the noise the complainant was making and went back to his log. The incident was caught on video.
Okay. I don't want him to have contact with this person. I'm not doing no threatening, harassing contact. I don't want you to have contact with this person. I don't care what you have to do. But if you try to have any kind of contact with them, and I don't care if it's accidental, I'm going to put your butt in jail. There are no more PR bonds. I'm going to protect my community at all costs. I don't care how much noise is going on. I don't care what the problem is. Do you understand, Mr. Lubos?
Yes, sir.
As also as a condition of your bond, you're ordered not to be in possession of any weapons. I'm not ordering him not to go there. I'm ordering no contact. So if you accidentally bump into this person, it's not going to go well for you. There are no accidents in this life. There are choices. You either make a good choice or you make a boneheaded one. And a boneheaded one may land you with me for a long time. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them. If they tell me they cannot get a hold of you, I will revoke your bond. Do not pick up any new cases. Do not violate these conditions. Do you understand?
Yes.
I will have you sign a reset. We'll have you take a seat in the jury box. So we get your bond conditions. Once you sign the conditions at that point, you'll be free to go. All right.
Okay. 60 sounds good.
Who's the one that didn't have it? She's glad she doesn't.
Yeah, yeah.
Yes, thank you so much. Violation. Yeah, I saw. I appreciate it. Do you know when he'll be back?
He just said.
Oh, okay. I was. Brandon?
The last one, what? I have one. Because I didn't like, yeah, it looked like something.
I'll thank you.
You're gonna tell us that.
Council, what is that? All right, yes. Okay.
Only one person, you can't find one to break.
Judge. Council What's going on with Alright, you're out. I'm trying to apply. And then the defendant was not that. Council for reset. Oh, happens. Right, you're still waiting on. I only get what I scheduled. Wait, the first time you
Yeah.
Well, we only go on the screen, well, it says on the screen. Well, so it's now like they are anymore. So there's
Come on.
I'm in contact with her.
Right. So we're gonna try to get this off the sheet here.
All right, no problem. We'll still.
Is that okay?
Yeah, absolutely.
All right.
Oh, I have. Oh, it's station. Make sure.
Is that your mom?
I guess we'll see.
Is it usually put that?
Yeah. Oh, okay.
He's got some big round white.
Yeah. Yeah, that's more of a language.
Anywhere else is planning? Yeah, no.
We're just trying to balance, right? Yeah. Online? Yeah, not for still. And you guys go back with me. It's. No, no sign, just a makeup. If you want to ask possibility over cases, you. Otherwise, I might use to use. If it's not the. But if it's natural.
So.
Make yourself. I don't know that either. You have to give us the number, also pass the judge. Right. I don't think they use this. Get out. Yeah, Yes, because.
So.
Yeah, he was supposed to. Yeah. Yeah, yes, no. It's a median for. Yeah, whenever, you know, that day, you did, whatever he says, like, he was like, hey, I'll just sign it. Now. I just just. I didn't do my research, but okay. So. But it's a record in there, so they keep the plan.
Whether there.
That's sign it. Just a minute.
So if you don't keep.
So yeah. Oh, okay. I'll put it in. I push it in from the date. I know. So he did.
All the range.
Yeah.
God's already.
Look at that, even if you're going to, spending a
Sure,
lot of
it's
money.
one protocol. You
Yeah.
don't do that.
Yeah. I think it was on the law.
Yeah, it's like when I said that, it's like, oh, I mean. Sure. How was it? Like you were still doing like that, and they didn't go with money, they can't go and they got it, they have to call it and start it here, I guess.
He is suspended for a year for the class number for the DWI second,
So that was.
ending in 966.
Yeah, I'm
The interlock
The reason
was for the probation. Okay. Okay.
English, first name, my friend.
All right, got it. It is not very well.
So I mean, I have. Something.
Anderson.
So, again.
Yes, this way.
Yeah, I know that you want the AFC to see. Right now, I'm just gonna break the street. Yeah, she started, right, so you could get it off the record, yeah. And I believe you did, key rights for her.
Mr. Newell?
Yes, Judge.
Hey, you ready?
Who is there, Your Honor?
Come on.
Bring him up.
Do you have a plea?
I do, Your Honor.
Okay.
So Mr. Rose Butler.
Are you ready?
Aye.
Okay. Mr. Butler, come on up. Oh, is he in jail? Got it. Okay.
Yes.
This is usually, it's at, April 9th.
You doing okay, Judge?
Pretty good. How about you? Anything new?
That's the money that's ankle trying to build some children's furniture, kind of 80-pound headboard falls and so.
Oh, you're lucky it's not broken, man.
Very,
An 80-pound, my goodness.
it looks pretty now.
You know, I have such weak ankles too. I can't even play basketball because I walk like this. All my shoes are, so when I play basketball, I invariably always just roll it and it's like it sucks getting old, doesn't it? God.
As soon as it was happening, I was like, I with my wife, I was just like, this is just an old injury all over. It just
Yeah. Just don't get on a ladder.
wouldn't dream of it, wouldn't dream of it. Sure.
Sir,
Over here first. Over here.
Victoria, you want to go ahead and appoint her someone?
Yes, Judge. No, I mean, sorry, you know.
Good morning, Mr. Butler. So you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 8 days in jail with credit for the 10 days that you've done. You need to understand that by pleading guilty to this charge will go on your record. It will be there forever. You will now be facing a minimum of 30 days in jail for any new cases that you pick up over here. You understand? You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. This is final today. You can never change this or challenge this. Is this what you want to do? How do you plead to the offense? I'm going to find you guilty. I'll follow it. Good luck to you, sir. Thank you. How are you?
Oh, much better. Good morning.
Good to see you.
Oh, yes.
Just make sure you're taking care of yourself, you know?
Yes.
So,
I'm approaching on Mr. Flores Raul.
okay. Where do you want to go with this? You want PTI? Do you want to just take something?
It's not eligible for PTI. They've offered us 12 months probation,
Yeah,
alternative for 30 days in jail. He's saying rather do the 30 days because of this,
okay.
but he wants to know if it is possible for him to turn himself in 2 weeks' time.
Yes.
Or just be said.
Yes, of course.
Thank you.
He's still under bond condition though.
Yes.
So even though we do it, he still has all conditions until he turns himself in. But yeah, of course. Yeah, just make sure you pick the date.
Okay.
Okay.
Morning.
Hi, Mr. Kim. Hi. Did everything work out?
One of them.
Did you get the phone like you wanted?
I actually didn't end up needing it, but I did talk to the first floor of the jail and I had 3 or 4 deputies looking at my paper. They said it would probably work and then I should take to the dudes.
Okay.
I mean, he ended up keeping the waiver, which is probably good for.
Oh, well, okay. So it's,
But he still needs his phone numbers. What do you have?
all right. So what's the deal, Pickle?
We're here on Abdul Haq, it's 2 last names, I don't know if it's either Abdul or.
Yeah, okay. I got it.
This client is hopeful that her warrant will be revoked tomorrow. The lawyers in Las Vegas called me yesterday and told me they have a motion and a hearing tomorrow to allow for a walk through bond, which would legally revoke the warrant and she would be released. If that doesn't happen, however, she is still interested in seeking a bond here and she is not wanting to reset her bond hearing until Friday. They just want to get set.
This is the one where she refused on the 20th, and the defendant jurisdiction has already let me know they've already started preparing a government warrant for me, so they want it. But
Do we have, do we have any indication that she's a flight risk? Is this a 2B? Is it?
it's a 2B, but it's a little bit mix of both. She's wanted for 3 charges. This was the one where it was set between 25,000 to 100,000. Basically our Texas analog of fraudulent use of ID and fraudulent use of. So it's all combined in effectively one transaction. But state would be opposed. This was August of last year. She stole a Navy Federal Credit Union credit card from another person who purchased about 32,179 give or take dollars worth of jewelry, which is apropos of nothing, but it's like a federal poverty guideline. But she sold that much in jewelry. Obviously, she started with it.
Wait.
So she went to a jewelry store with a stolen credit card, purchased roughly $32,000 worth of jewelry, and then, left with it. And then the complainant for the credit card states that the defendant did not have permission to use it. Obviously, the jeweler with a fraudulent purchase did the complainant into that because it was obtained by way of fraudulent activities.
And of course, Your Honor, my client denies all allegations. She already has a lawyer in Las Vegas fighting it as well. Not a flight risk if they're appearing in court.
The only other history that she had is a distance domestic in 21 because of requested complaints.
But this case has been allegedly open since.
Well, I know the incident was in August, but I believe the warrant was issued out on, let me tell you, in December. I imagine they did some investigating with surveillance video and credit cards and grand subpoenaing or search warrants for bank records.
Which she had no.
I don't know. I really don't. If you have a lawyer in Vegas and they're prepared to do a walkthrough, once that hits, then you're not going to have to pay anything. If I set you a bond now, it's going to be high to ensure that you make it back to Las Vegas. I'm not going to set these. You're a fugitive from justice, so you're an inherent flight risk. If I set you a bond, it's going to be rather high to ensure that you go back because, I have enough drama in my life. I don't need any more, and I certainly don't want anyone else hurt on account of setting a bond. So we need to make sure that it's sufficiently high. You understand? Sorry? So what we can do though is if you guys have a lawyer, we can set it a day or two. And if that does work out, then they'll release you. But you need to understand that you can't just, not do anything. If they do set you a bond over there, you have to go back to Vegas and you have to take care of these things. You can't just out of sight, out of mind, because, once you have multiple fugitive cases to judges, that indicates more and more of a potential flight risk, and it makes things worse all around. We don't want to see a bunch of cases. We don't want to see any indications of flight because it just makes everything so much worse.
Yeah, that's the plan. I have to get back to work. So this is my worry. I didn't want to wait until, I don't know, okay. So
Well, my concern is not your work. So if we set you a bond, I don't care that you have to work. I need you to go back to Vegas, and that's my concern. And you can't use, I got to work, so I can't go to Vegas. That doesn't.
Oh, no, that's not what I was saying. That's not what I was saying. I have a lawyer already. Like, I'm trying to take care of it. I can't go straight to Vegas and take care of it.
Do you want
But
to?
don't set me up on, I'll wait until see what happens.
If for some reason it doesn't work out in Vegas, I can hear you more, and then we can talk about. I'm not going to go nuts on your bond, but it has to be sufficiently high that you understand that we mean business, and that if you don't go back, there are severe consequences. I'm going to tell you now, if we do set you a bond and you take off and you don't go to Vegas, I'm not going to do this again. I get a lot of people that sell me the sun and the moon and the stars and, but you need to understand that actions have consequences, and especially in light of something like of this nature.
Can we move to Friday?
Sure, of course. Do you want to?
Because she's not approving time while she's refusing. That's why I want to double check.
The thing is, this also is that you know, you have refused. So essentially, every, once you waive, we give the demanding jurisdiction here, Florida, 14 days to come get you. If they don't come get you within that 14 days, then Harris County releases you. Sometimes they come, sometimes they don't. It just depends on the person. So, but while you have refused, no time is accruing toward that 14 days. It's just kind of in a holding pattern. What they can do is, okay, all right. Regardless, though, if you want to set it for Friday, if it doesn't happen, then let's talk. And
Right, 'cause it's-
I will set you one. I'm telling you, I'll set you one, but it has to be sufficiently high so that you know that it's,
What range do you need?
I don't know. I don't know. Let's see first if that plays out for you. Okay? So you save money.
Thank you, Judge.
Okay.
Touch on a couple of conditions in your view.
Maria,
Hi.
good morning.
On the folks from
Just the last name.
McNeil.
You said Mejia?
McNeil.
M?
Curtis Joe McNeil.
Just the last name.
His last name
Is that with an M?
C and then NEI.
Okay, McNeil. Okay. What's the word?
Judge, I'm asking for a reset because I got an offer just today. The offer is, take a gun safety course and work with the weapon and his case will be dismissed.
Okay.
But there's, and his appearance was late today, so.
Sure. I'll give you a week. Okay. The case is 180 days old. We'll give you a week. Okay. If he doesn't have it done, then he's got to be here. Okay.
Yes.
Yes, ma'am. Okay. Victoria, what was that cause number again, please?
596-828.
Ms. Sullivan, come up, ma'am.
Yes.
Good morning, ma'am.
Good morning.
Ma'am, you are charged with assault bodily injury. You are facing up to a year in jail and or a $4,000 fine. You were supposed to be here on December 22nd of last year and you failed to make it. We issued a warrant for your arrest.
Yes, Your Honor, I have.
Stop. I'm going to reinstate your bond today, but I'm not going to continue to do this. If you continue to miss court, the next time I will revoke your bond and you will go into custody.
Yes,
This is not a revolving door. You understand?
yes.
Who is the complaining witness in this case? Oh, I have to give you cause number. It's not on docket. 259-6828.
The planning witness is. The court doesn't want the name, let me try to actually.
Yeah, I'm not, the name doesn't do anything. I mean, is it a friend? Is it a relative? Is it an unknown person? Did you get the cause number? Okay.
I don't see no relation, Judge. The complainant is an employee of group home. It's not that is outside of that group home.
Okay. Ms. Sullivan, as a condition of your bond, I'm ordering you not to have any contact with the complaining witness in this case and not to be in possession of any weapons. If you attempt contact with this person, or if you pick up a new case, I will revoke your bond, put you in jail, no more PR bonds.
Yes.
Do you understand?
If they want contact with me.
Then you cannot have
I'll get a
contact.
restraining order.
Don't have contact with this person. I don't care if they reach out to you. Do not reach out to them. Do not text message them. Anything like that. Do you understand? I've already appointed you a lawyer. Do you know who it is?
Basic Childs.
Okay, can you file conditions on this? I just reinstated a bond.
Okay.
For now, I'm gonna have you go to Victoria. We're gonna have you sign a reset. I'm gonna have you take your seat in the jury box. I'm gonna get you bond conditions. Do not leave until you sign these conditions. And then I'm gonna have you meet with a lawyer here momentarily.
Okay, thank you, Your Honor.
All right, please.
They're filed, Judge.
Thank you. Mr. Nooley,
Yes, Judge.
are you ready?
I have a feeling all this done.
Okay.
Well,
Mr. Flores, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 30 days in jail with credit for the 2 days that you've done. This charge will go on your record. It will be there forever. Every time you get pulled over, officers will see DWI, DWI. If they smell alcohol or dope on you, what's going to happen?
don't take me on surrender.
Probably don't have anything if you're going to get in a car and drive. It's not rocket science. Do you understand?
Sir. I'm not listening to her. I want to do this again.
Yet here we are. Second, when is when? Is it going to take prison? Is it going to take a death on the road? How many people say this thing to me on a daily basis, Mr. Flores? Yet the problem is one thing. It's arrogance. People start consuming, and then the all familiar arrogance takes over. I can do this. I can do that. Even if you get the feeling you think you can, don't take an Uber. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, you are stuck with us until it's, well, forever. Do you understand? How do you plead to the offense, guilty or not guilty? I'm going to find you guilty, sentence you to 30 days in jail. When is he going to turn himself in? So I'm ordering you to turn yourself in April 10th, 2026 by 6 p.m. If they don't take you, the full range of punishment is available to me. Do you understand? You are still under bond condition in this court. If you consume alcohol, if you consume illegal drugs, if you get called to test between now and then and you fail to go, the full range of punishment is available to you if you violate. Do you understand? All right. Good luck to you.
Thank you.
All right. Oh, 1 year driver license suspension. Yeah. Okay. Kavita. Hi.
And I don't know if I like this.
What did you have in mind?
60 days.
What is it?
60 days.
Hey, did we do a T-RAS? I think that's the appropriate thing.
Just, treatment program that he's going. He has a job, he works full time, so he's going to treatment programs between his work.
Tried it, been there, done that, been on probation, got another DWI while on probation.
He hasn't done the treatment program prior to this meeting.
He completed the DWI education course on February 27th of 2025, victim impact on February 20th, IOP on May 5th, and SOP on August 30th.
This right here is a slow plea to a felony offense. I'm not going to do it.
Well, and then the family court cannot figure.
I'm trying to prevent him from ending up in felony court.
I don't think they're gonna have more problems out of this.
Don't believe it for a second. I'm amending your conditions to put you in a treatment facility because I think that's probably the most appropriate thing. Mr. Mayfield, you have continued to violate over and over and over. You're on probation for DWI. You pick up another DWI. While you're on bond for both, you continue to violate conditions. I'm not, this 20-day sentence is a literal slow plea to a felony offense. And I'm trying to prevent you from either killing someone or ending up with a felony DWI, because apparently the message has not gotten through.
There's no violation on this ground since we've been on it. Airlock violation, about airlock control. The violations you're looking at are technical versus curfew. He left an hour early their curfew, so he fell to the airport. He should have gotten an Uber, but he hasn't had any other violations as far as drinking is concerned.
All right, Karina.
Skype is not gonna be an option for him. I don't, I think he'll be able to do the job or support his family with that. And that's why I continue to take care of 3 kids off their own while he's there in a treatment facility. And he's already taken steps to put himself in a treatment facility, which is outpatient for the people who live and work and support his family. This will be detrimental to him as he goes into society.
Yeah.
His wife is actually here today. They have 3 small children under the ages of 10.
Which scares me even more because of all this stuff that we have here since 22, all these cases, all these issues, and he's got 3 young kids. How many times have the kids been in the car when we had all these issues? That to me is so much scarier because
His responsibility.
let me do this. Let me talk to them. I don't think that this is an appropriate. I don't. I'm sorry. I think we're setting him up and setting everyone up for failure.
Been feel for a long time, and I think some of you not going to be able to go.
I don't believe it. I don't. I know that you're saying that, but evidence everywhere with the contrary.
Send a lot of people, and this is one that I'm shocked even picked up the case. So he has taken steps. I think he was going through.
Kavita, let's do this. Can I help them out so they don't have to wait any longer? And then we'll come back and talk, please. Do you have to go?
I do. I'm having.
Okay, then go. We can tomorrow or the next day,
I'll be in another county tomorrow, so
Friday?
it will hopefully be on Monday, guys.
Okay, but I'm telling you now,
What can we do to change the mind?
nothing. I don't think anything. I mean,
And one of the things I would do with the attitude of the situation, it would do more for his family than really behind on that.
this is what he needs to think about when he's out there in the free world, right? And when you're on bond for a DWI, you pick up another DWI. These are the things that you think about, not when you're in jail and everybody's, you know?
Alcohol.
Yeah.
No violations.
Okay, let me,
Who was Christina?
hey, sorry to keep you
And
waiting.
Anderson?
Ortiz for a plea check. Okay. Then you have a plea with the pro.
Calling 2 people from the box. Executive the box.
Oh. I got him.
You're Anderson. Who was Christina?
That was the reason you guys would be over there. Bueno, la Luis, que es aquí, por favor. Después de contestar en español, nada más.
Mr. Ortiz, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement. They're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that this charge will go on your record. It will be there for the rest of your life. Even after you die, it's still there. This is important because every time you get pulled over, officers will see this. If you smell like alcohol, if you smell like dope, and they see a prior DWI, what's gonna possibly happen?
They would arrest me.
For the rest of your life, if you have even a sip of alcohol, don't get into a car because it is a huge risk. Do you understand? We want our streets safe. We're not asking for much. You give up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf. Confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you plead guilty, this will go on your record. It will stay there forever. From now on, it is a minimum of 30 days in jail. Do you understand? There are no more proverbial slaps on the wrist. I have to suspend your license. I will do it for the minimum, which is 90 days. Do not drive until you get a license. Good luck. Or how do you plead? Guilty or not guilty?
Guilty.
I'm going to find you guilty, follow the agreement, sentence you to it. Good luck to you, sir.
Yes, fine.
We waive it on the first.
Yes.
Yeah. Okay. Good luck, sir.
How's it going? Pre-trial supervision, and he has portable witness, right?
It's once it's done, then he goes down there and he'll. Yeah. All right. Good luck.
Thank you.
Thanks. Mr. Villarreal.
Morning, Judge. How you doing?
Hi, bud. How are you? Just the last name of your client.
Salgado.
Salgado.
Asking the court to run, reset, why. He's done everything. The only thing he's lacking, putting, he talks to like our bribes from the people. And, he's supposed to do that. He's already called him.
So has he made an appointment yet?
He's called already. He doesn't have the appointment yet. I told him you should have to get that done.
So we're gonna give him a week. Your case is 210 days old. So, yeah, we'll give you a week.
Okay.
Let him know if he doesn't have it after that point. I'm gonna roll him till he gets it done.
All right, Judge.
Yeah? Okay,
Thank you.
thanks.
Mayor Burke?
Please.
Judge, I got Deonta Dennis.
Okay.
His case is getting a little old. I think it's about 170 days. His appearance was required today. He called me yesterday to let me know that he had been admitted to West Oaks Psychiatric Hospital.
Do you have some kind of proof?
I asked him for documentation. He hasn't sent any yet, Judge. Could we maybe,
It's 182 days old.
could
So
we reset it a week or two?
we did that last time.
Okay.
So, I
But
mean,
you know, I was happy that he had reached out to me to let me know.
pick a day next week, SFBF. If he's not here,
Right.
then,
1 week. Okay.
any day next week, except for Friday, because it's Good
Okay,
Friday, right?
I'll set it to next Wednesday.
Sure, SFBF.
Okay.
If he's not here,
Understood. I'll try to reach him.
All right.
Thank you, Judge.
hey, wait, hey, do you have an offer on these cases?
Yes, Judge, it's deferred.
So let him know because it's plea or trial on that day too.
Okay.
Okay,
Thank you, Judge.
all right.
Morning, Judge. I have an off docket,
What's your cost number?
259
Okay,
7347.
okay.
Mr. Vela?
Did you just bond out? No.
No, he's on bond. It's questioning about his curfew.
Okay,
He's provided me his work schedule. On most days, he works from 7 a.m. to 8 p.m. His curfew, I believe, is 9 to 6. He'd like to be able to leave earlier to go to work and stay out later.
no. I mean, for work purposes, I'll let you do what you need for work, but I'm not letting him stay out in the middle of the
That's what I
night.
mean, for work purposes.
Sure, give me the time. You said he works until 8?
He works from 7 8, he's working 13-hour shifts
Okay,
from 7 a.m. to 8 p.m. I think currently he has to be in at 6.
sure. I'll give you till like 8:30 or so, but only on the days that he's working. Yes, but we want proof that he's actually working. We're not going to take his word for it. And then show me the schedule. And just for those days that he's working, we need to know how far it is from his work. I mean, we're not going to just give him whatever he wants. He's on 2 defers for felonies. He picked up another case. So we're keeping it very, come up, Mr. Bela.
These, just so you can see, these are his workout with the 70.
In a matter of a year and a half to 2 years, you have picked up 1, 2, 3, 4, 5 cases. You're on deferred for 2 felonies and now you've picked up a new case. I'm keeping you as close as I possibly can. 1 violation. It's really not going to go well for you. Do you understand me? Any more violations, your bond's now at 15,002. Any more, it's going to hit the nubes. Do you understand? So I need to know how far from the work. Well, you guys talk, but I'm not going to take his word for it. I want proof for everything, where he's working, where the house is, how far the house is to his work, and then only on the days that he's working. And we're going to verify with your job that you're actually doing these hours. I'm not going to take your word for anything. Do you understand? No. We are going to do it. We're going to call the work because I'm not going to have, I want to make sure that we're calling and we're talking to the right person.
Right.
Do you understand?
Any.
This life is about proof. This is a court. We work on proof, not on gospel. Do you understand? We work to protect our city at all cost. I don't care who you are. I don't care how old you are. With as much drama as we've had in the last year and a half, 1 false move, I'm going to go bananas. Do you understand? The only time I'm giving you is for work and nothing else. I need them to verify that you're actually working steadily for 13 hours a day. You were not allowed to go to 7-Eleven. You were not allowed to go to Burger King on the times when you're supposed to be working. It's home to work to home. Do you understand? Okay. Well, he can obviously eat lunch. I mean, I'm not saying he can eat lunch, but I'm not giving him out to go dilly-dally here or there, go hang out with friends. No. No. You guys talk and let me know. All right. Counsel, what's your cause number? I'm assuming since you got a warrant issued. What's your cause number?
It's 259.
Okay.
3144. 2 cases.
On Addison.
Yes, Your
All
Honor.
right. Do you mind bringing them up, please? Did you get the cause number?
I think that, yes.
Did you get it, Victoria?
Yes, Judge, I have it.
Did you get it? You got it?
I did.
Mr. Addison, you're charged with 2 cases. You're charged with the assault of a family member and unlawful restraint. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
So judges for the
Let's do both.
Okay.
Dealer's choice.
So the unlawful judge coming from the DINS on November 6th, 2025, officers dispatched a disturbance and a weapon call. In Harris County, officer arrived on scene and met with the complainant. The defendant was on scene at arrival. Complainant advised that she and the defendant were in a dating relationship for 3 years. Said the defendant saw her playing a game app on her phone and he thought she was cheating on him. Complainant said the defendant and her got into a verbal argument. The defendant shoved her into their bedroom and closed the locked door. The defendant placed the chair in front of the bedroom door and he sat down on it. Sat there so that she would not come out. Plaintiff said that whenever she would get close to the door, the defendant would get up and intimidate her to go back in the bedroom. Plaintiff was scared and nervous that she never used the restroom and was released the next day. Plaintiff said the defendant gave her food, but she was scared. The defendant was eventually released from the bedroom. The plaintiff said the defendant gave her back her cell phone. And then a notification went off and the defendant got agitated and demanded the phone back. The plaintiff refused. Defendant grabbed her phone and by her chin and the top of her head. She thought it was going to break her neck. Plaintiff dropped her phone. Defendant snatched her phone.
valued at $1,200 along with their other electronic belongings, iPad, and smartwatch, and left before the police arrived. That's,
The assault, is that of this or is this a new, is it another
that is a
case?
separate case, Judge.
Different
Same
defenders?
complaining witness.
Same complaining witness?
Yes,
Okay.
Judge. The assault is on an officer conducted a follow-up investigation. The complainant advised that the defendant, her ex-boyfriend, and her on December 24th in Harris County went to HD on Shepherd. The defendant was driving and their kids were in the car. The defendant received a call from a bondsman of a previous case the defendant had. The complainant was facing the window of the car when the defendant then struck her 2 times in the left temple, causing pain. The complainant was transported to LBJ Hospital for head injuries upon arrival at PHEB.
Okay. Do you see anything else that's open? Can you run an NCIC?
I can remember that.
Please.
I'm not seeing anything else on the judge.
Okay. Veronica, can I get a PSR on Mr. Addison, please? So what do you think about bond, guys? What's appropriate?
I'm asking for 2,500 at each, Your Honor. My client is 40 years of age. He does have 3 children that he supports, ages 19, 15, and 11. They all live with him. He does own his own business. He escorts 18 wheelers for a living. He goes interstate to do his work. Generally, he works 5 days a week. He's a lifelong resident of Houston, Texas.
What do you think? 2,500 on both.
Yeah, okay with that, Judge.
Okay. I'll give you what you're asking for. You're asking, and I'll set both of your bonds at $2,500. I want you to understand something, Mr. Addison. I'm going to protect my community at all costs. I don't care who you are. I don't care what color you are. I don't care how old you are. If I have to set your bond at $2 million, I will do it in a heartbeat. I've done it before, and I'm not going to lose any sleep over it. As a condition of your bond, you're ordered not to have any contact with this complaining witness at all. I don't care that you have kids. I don't care that you got a billy goat and that you need to contact her to do it. You have contact, and any contact with this person, I'm going to put your butt in jail. I will revoke these bonds and I'm going to set them high. I'm issuing a protective order on both of these cases that identifies Ms. Johnson as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot stalk, threaten, harass, use another person to communicate a threat, harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. This includes the address on Annabelle. Do you understand? Any contact whatsoever, and I don't care how minute it is, you will go to jail. You're in violation, and it's very possible they file a violation of a protective order. That is one of the worst misdemeanor cases you can pick up. Do you understand? Do you mind reaching out to the complaining witness to let her know what we've ordered? No contact. He's not allowed to go to where she works, where she lives, no weapons. So that if he attempts anything, you guys let us know and we'll take the appropriate action.
Yes, sir.
Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with Mr. Holt. If he tells me he cannot get a hold of you, I'm going to revoke your bond. There's not a revolving door. You will not get any more PR bonds. Do you understand? If you pick up a new case, if you violate these conditions, it's just not going to go well for you. I'm, Mr. Addison, not asking for much. I want my streets safe, and I'm going to do everything in my power to protect you. You understand me? So for now, we will have you sign a reset. I'm going to have you take your seat in the jury box while we get your bond conditions. Once you sign everything, at that point, we're going to release him to your bondsman, and then you guys can walk through to go do all the bonding paperwork. At that point, you will probably get a new date. Just reach out to Victoria and we'll give you whatever day you want. After that, it'll be probably like a 2-month reset or whatnot. And
Yes, Your Honor.
I don't care. You can have whatever you want. Okay. And obviously be waived for the first couple of settings. All right,
Judge.
please.
Judge, what was the bond set at?
Each at 2,500.
Okay. PR bond or pre-trial bond?
No, he's gonna go with Rick. They're gonna escort him to go do the paperwork. He needs to sign the MOA and it'll be state's bond conditions. So on both cases, if you don't mind filing, no contact with the wetlands, please.
Yes, sir.
Judge, I have, Mr. Mendez, the bond set, just an update, for contact.
Okay, thanks. Yeah, I'll take it. Thank you.
You've got it, really. Yeah, it's
I'll-
all that. Yeah, at the end of the day.
You too, Rick. Looking good, man. Dan, you ready?
Hernandez.
Okay, signing it now.
Thanks, sir.
Yes, sir.
I appreciate it.
Hi,
Morning, Judge.
good morning. How are you?
Good, how are you?
What's up?
I have Aquila Norvell. This is one that you have coming every 2 weeks to check in about employment.
How is she doing?
She's doing good. She's still.
Oh, just the hair?
She's still doing hair, Judge, and is still being consistent. She does have an appointment today, though, for her medication that she's on to see if she's cleared to start doing the nursing home job that you prefer that she does, but that appointment at 1:30 today. And because she's been coming every 2 weeks. since
Yeah, I'll give you a longer reset,
Okay,
for sure.
thank you. No.
Tell her to stay out of trouble.
Yes, sir. Thank you, Judge.
Yes, ma'am.
Yeah.
Okay, hey, Colin.
Hey.
What's up, buddy? Long time.
Yeah.
How are things?
One of these days,
Say it again?
Monday, 4 of these days, there's just old cases coming in.
That's okay. What's up?
So we have cases up for trial on the 31st. And
Okay.
I'd like to inform if they're resolved before the trial date. So Byron Davison, we have reached an agreement at PTI.
Okay, so I'm sure it's an old case, though?
Yes.
So what is the agreement?
Of the point in August.
What's the agreement, though? Would you guys,
6-month PTI where he's.
so supervised PTI?
Yes. No, sorry, no,
It's just conditions.
Did you say, what else did you say?
just the class.
What's the point of doing 6 months if he's not supervised? You know what I mean? So the quicker you get, so
I
Because
think originally.
there's just no, it's nonsensical to leave it lingering for 6 months and just,
There was originally a supervised part of it for the 6 months and then it was brought down. So the operator did for the.
so you guys talk before that, so we don't have to sit there and just keep it open for 6 months just for, it just, I mean, I'll give you a reasonable amount of time, a couple weeks to get everything done, I mean, but there's no sense in just keeping the case open for. How long is the class? If it's a 2-hour class or a 3-hour class, there's no sense in keeping another month when it's already 200 days old. You know what I mean? So have your client come, I guess, on that time, on that day.
On the court date.
So we can figure out, or unless if he gets it done by that time, hopefully we can,
I can just tell him, hey, he has to show up unless the case,
Whoa.
things are done.
hey, if you get it done, maybe it'll get done on that day.
Right. That.
Right, have him do it now.
So.
Yeah,
If I get told it's done, I'll take care of it tomorrow.
get on it, doggone it.
Hey, it's not my work to do.
I know,
I can hit the ball, he's got to run the base.
got it. Hey.
Hello.
Okay, all right.
Yeah.
Damn, now two of you in here?
Hey, Judge.
Area.
Mr. Whetstone,
Sorry.
Yes, Judge, can you hear me? Hello?
Deputy, do you mind on the sound bar hitting the button all the way right over here? There should, on the sound, no, sound bar right over here. On the end, there should be a button. No, other end. Just in the middle, a power button, if you don't mind. If you just touch it one time. Mr. Whetstone,
Yes, sir, can you hear me?
one more time.
Yes, sir, Judge.
There we
can
go.
you hear me?
All right, I got you.
Yes, sir, good morning.
Hey.
Judge, I just wanted to let you know, Adam filed a motion to substitute on Mr. Gray's case.
Hold on, what's your cause number?
Oh, Judge.
Yes, sir, one moment.
Top of 33. Is that it?
Yeah, yeah.
Judge, the cause number is 259-5705, Judge.
He filed it yesterday. Don't worry about it. Neil, you're fine.
Okay, Judge, I just
I'm gonna
wanted to
sign
get
it.
thorough.
I'm
Okay,
gonna
thank
send
you.
it now. We'll
Thank you.
get you off.
All right, thanks.
Thanks, bud. Take care.
All right, bye-bye.
Okay. Hey. Okay. All right. Good morning, Mr. Gonzalez. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement. They're offering you 36 days in jail with credit for the 12 days that you've done. You need to understand that this charge will go in your record. This is especially important because there's an affirmative finding of family violence. What that means is that if you ever pick up another case like this again, and it doesn't have to be a beat down drag where you beat the hell out of someone, no, just grabbing an arm, squeezing enough to where it hurts, you may be facing a felony, a 3rd degree, 2 to 10 in the penitentiary. Do you understand?
Yes, sir.
You can never own a gun or ammunition as a result of this plea as well. Do you understand?
Yes, sir.
You were giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, you cannot change this. You can undo this. It will go on your record, be there forever. Is this what you want to do?
Yes, sir.
How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty, sentence you to the 36 days, give you credit for the 12. Like I said, there's an affirmative finding of family violence. Good luck to you, sir.
Thank you, sir.
Thanks.
Appreciate it.
Take care. Hey, Velas, squared.
All right.
Are you ready?
We're here, Mr. Abish Patel, PAT.
Okay.
Defense offers anything. Average. Whatever.
Say it again.
I think they're gonna refile it, Judge, at the third, but I did give them a week to do it. We're here today. I'm not here to do anything other than.
What's the deal, Pickle?
It's going to grand jury on April 1st.
We're here, we'll take a year into county.
I was told to hold off and not plead because of that.
Right, I can't. So I guess we'll set up for, if it's not done then,
Yes, sir.
I'm giving you a 10-day trial setting. I'm telling you now, I'm giving you a 10-day trial setting if it's not indicted by April 1st. The case is 193, it's gonna be over 200 days old. I'm telling you, 10 days, I don't care.
Absolutely. Yes, sir.
Okay, so that's it.
We'll announce
Yeah,
ready.
just be ready.
Yeah, we will.
Yeah. Okay, all right. So I guess for April 2nd, just let's do the day after. That's what they're saying, it's get indicted at first, so that'll be next Thursday.
Yes, sir.
So I'm not gonna be here.
Okay,
So Judge Singer will be here,
okay,
but just tell him that I said that and let her write it in the notes, that if
Okay.
it's not indicted by that day, then separate file for 10 days.
yes, sir.
Okay,
Thank you, Your Honor.
thanks.
Good to see you.
You too. Take care, guys.
Judge, corporate sale, is that waived or required?
Wave, there's no need.
Thank you, Judge.
Thanks.
Just based on, that was the one who made the payment, hours. So you don't have to that invoice is 6 p.m. and the conditions 9 p.m. to 6 a.m.
Yeah, no, I don't want him out in the middle of the night. Right.
The conditions are already there for them, so I'm explaining to him that he's allowed to do, like, it's just waiting until that 9 p.m. And so,
No. Well, okay, until 9, right, 9.
Yeah.
Sure.
so the conditions do not need to be amended because they already state that.
Okay. Right. I think what the problem was is that he may need to leave a little bit earlier for work is what I think the issue may be.
Because he said that he needs to leave by, he wanted at 6:30 and he already has a 6 p.m.
Oh, okay, then, okay.
There's no reason to.
Got it. Right. Okay.
Thank you.
Hi,
Hi, morning, Judge.
just pretty good. Just the last name of your client,
Mendoza.
Mendoza. Jail or bond?
She's a cut, she's down.
Mendoza. Mendoza. Okay,
Good morning, Judge.
hi.
Okay, so we're here for PC for Ashley Mendoza. She was arrested in December.
Okay. What would you guys like? Do you want to do PC?
Yes, the rest of the court.
Okay,
Okay, on the most, okay.
it's a theft.
Uh, On December 5th, in Harris County, officer was dispatched to the Pasadena Food Mart regarding a theft. Complaining witness stated she allowed her grandson to play on her $900 phone. The grandson placed the phone at a table when his father arrived to pick him up and was taken outside. When complainant returned inside, the phone was missing. Surveillance video showed the defendant walking past the table when complainant left and snapping the phone. The next day, a witness called the complainant's phone and a male answered stating he was unaware the phone was stolen and to pay him $60 to get the phone back and putting the money in a residential mailbox. Officer went to that residence and observed defendant wearing the same clothes as those in the surveillance video. Defendant stated she was told to take the phone away by the male. Defendant stated she did not know where the phone was and that male acquaintance whose name she did not know had it. In defendant's possession was the iPhone case without the phone.
So there's surveillance video of her taking the phone. Correct?
Yes, Judge.
The value of the phone is what?
900.
Go for it.
All right. The phone that was alleged to have been taken was a $900 iPhone 15. When law enforcement approached the home and saw her standing outside, the summary on the case states that a phone case was found in my client's belongings, allegedly found in her belongings. However,
There's no mention in anything on this case, whether it was an iPhone 15 case, what type of case it was. There's nothing also in the record that even states that the phone had a case on it. Or describes what that case looked like if there was a case.
Well, I don't care about the case. I care about the phone.
Correct. So there was no phone. No phone was ever recovered.
Well, I get it, right? But there's a video of her allegedly taking an iPhone 15 from the supermarket. Right?
We have not seen the video yet, Your Honor.
Right. Unless that's not true, which I'm well to entertain it, but I mean, we have here an allegation that she goes in, takes the phone. We know what kind of phone it is. We know the value of the phone. It's not in their possession when they go to the house, but I mean that it's everything's still, I think there's enough probable cause to go forward. Sorry. She's still in custody, and the problem is that she's failed to appear on numerous occasions. Let me see.
Yes, Your Honor, she missed the court date. She had received counsel on this case, which fell back in December. And so she missed court. I was picked up in San Antonio. And it's our understanding she was in custody in San Antonio for quite some time. And now she's here, but I'm not sure exactly how. It's hard to know exactly how long she was in San Antonio when we lived in that time.
So normally if someone gets arrested on an out-of-county warrant, let's say this warrant's open in San Antonio, somehow she gets picked up, let's just say a public intoxication. They'll put her in jail because of this warrant. They'll notify Harris County, hey, Harris County, we picked up Miss Mendoza, need to come get her. They'll give Harris County 10 days to come get her from San Antonio. If they don't come get her on the 10th day, typically they'll just release her and they'll say, hey man, go to court. And then the warrant remains open and active if and until she either post bond or she comes to court to take care of it. Here, presumably, nothing ever happened. She didn't come back until somehow she got picked up again. I don't know how. And so that's why she's in custody now. So I'm going to be hard pressed to give her a PR bond knowing that it's over and it's over and it's over, because if I give her a PR bond, what's going to happen?
The argument that we would make, Your Honor, is that the defendant, my client, Ms. Mendoza, she did not have representation. She did not know she was in San Antonio. Had she had adequate representation, we believe that she would have appeared. We do have our contact information as well.
Let me ask you this. Have you spoken to any family members for her? Because I would consider it giving her an ankle monitor so I know where she is. That's the only way, because if I give her a PR bond, I don't think we're going to see her again. But hopefully if I put a monitor on her, it'll kind of get her to come back, because no one wants that monitor on, right? But my only issue is I don't want to give her a PR bond to be on the street. So if she has nowhere to go and if she's just going to be living on the street, then I'm not going to do a PR bond. You know, but if she has a place to go to, if we know that there's someone that's willing to take her in, where she has a house to go to, I'm more amenable to it, but only by giving her a monitor so we know where she is at all times. With the admonishment that if it ever happens again, you will not get another chance, because then it's 2 times you've, taken us for a ride, so to speak. So
We do have her father's contact information, and she will be.
I get it. That's not good enough though. If you don't mind reaching out to him, because a lot of times they have it, but they're not willing to take him in because either this or that, or there's too much drama, or if you don't mind, reach out to the father, see if he's willing to take her in. If no, maybe a brother, a cousin, sister, anything. If we do have someone that's willing to take her in, come back, let me know, and then we'll give her a PR bond.
She does reside with her father, but we will.
Just, I want to know that, hey, once she leaves, they're willing to take her in. And then, as part of the condition, she will have to go live with him. So we know she's not on the street or out doing shenanigans, Okay.
Thank you, Judge.
Yes, ma'am. Okay. Hi.
Good morning, Judge.
Good morning.
Castellanos on Docket today.
What's the last name?
Castellanos. If I say it correctly. He has two terroristic threats.
There we go. Okay,
I would like to go over probable cause for both of the terroristic threats.
okay. Go for it.
Starting with the one from February 17th. It was filed on February 17th. So February 14th offense. On February 14th, officer was dispatched to a threat to life at a business in Houston, Harris County at 8:51 in the morning. The report stated that on the call slip, her ex-boyfriend, the defendant, was on his way and was threatening to blow the place up. Upon arrival, officer found the reportee was not on scene when the threat was made. Officer observed the doors to be locked and complaining witnesses hiding inside behind the desk. Complaining witness one stated she received a phone call at the business from the defendant who stated, "Y'all better close that clinic because I'm on my way to blow it up."
How do they know it's him?
Complainant one had the phone on speaker. Complainant two recognized the voice and asked who this is. Defendant stated who his name of Jonathan Castellanos. Defendant stated to complainant witness two that you're going to be the first to go. Complainant witness two stated the defendant had visited the business multiple times due to a previous relationship with the owner, the reportee.
Okay, I think we're good. I'm gonna go blow this place up.
Correct, Judge. It doesn't rise to a reasonable imminent fear. He was on the phone. He wasn't even at the location.
He doesn't have to be there. But imagine how many.
And identity as well. They allegedly said that he says, "Oh, this is Jonathan Castellanos."
He's been there before. They recognize a person. They recognize his voice. If you call me, I know. If Victoria calls me, I'm going to recognize her voice. She doesn't have to tell me who she is, but I'm going to recognize it. I think there's enough on that one. We'll go on the next one.
Sure. Yes, sir.
Okay.
The next one on June 17th, 2025, officer dispatched to 7705 Wright Drive, Harris County. The complaining witness on scene told the defendant to leave the location. Defendant refused to do so. Defendant threatened to return with a gun and then kill the complaining witness. Complaining witness had video footage of the interaction.
Okay, so say that one again.
So officers dispatched to an address.
Okay.
Complainant told the defendant to leave the address and the location. Defendant refused to do so and threatened to return with a gun to kill the complainant. The complainant had it on video.
Again, he said that he would return to the scene and allegedly shoot him. There's no statement of that there was a gun on him or that he was making any gestures that would indicate that he was going to shoot. He said he would come back as a future threat. That's why I don't believe it rises to a reasonable fear of imminent bodily injury.
Is this the same place?
No, sir.
This is a different place?
I've spoken about this one, actually residence, where, yes, the defendant came to the property, was there. And then,
What do you think, or to her response? Sean?
as far as probable cause goes for the DIMS, the imminence of him saying, "I'm gonna come back and shoot you."
No, he said, I would come back.
Determine the gun.
Does would indicate imminency? I will come back and I'm gonna kick your butt. I would.
Right.
Is would conditional? Is it imminent? Is it enough, or was it enough of a statement to put the person in fear? And how do you quantify that? How do you show me that the person was in fear, so to speak?
Right.
What do you have?
So just from the DIM judge, the complainant had footage of the defendant on property making threats and trying to break into one of the shops in the property. And then was asked to leave, and that's where.
Well, now you're adding new facts to it. You're saying he's
understand.
trying to break in?
So that's just, I went straight to the threat. This is.
No, but you know, in these types of cases, a lot of times there are other collateral things that happen that can help, so to speak, because other facts can indicate an intent to come back. So what time of day or night was this? Is he really trying to break in? Is this the middle of the night he's breaking in? Is it during the day?
Didn't say the time of day, Judge. That's.
Okay.
Actually,
How do you know he's trying to break in?
The complainant had video of the defendant on property making threats and trying to break into one of the shops on the property. Got the name of the defendant from a tenant who had done business with the defendant in the past. The video footage showed license plate of the vehicle the defendant was driving.
So there's issues in the past with these people?
On the, sounds like the other businesses in this location, one of the other tenants over there told the complainant that they recognized the defendant. So I understand that there's still the wood come back and shoot you, but I would argue that if someone is trying to break windows and get into a place and then when asked to leave, so that he's going to break back with a gun, then, you know, that would put me in fear for my life. So
Would a reasonable person be in fear in that instance?
No, Judge, I do not believe a reasonable person.
If someone's breaking into your house,
Well, they don't even, the DIMS doesn't even state what actions that they saw that made them feel like that the defendant was breaking into the property. All it says is the defendant on property making the threats and trying to break into one of the shops on the property. It doesn't indicate what specific shop, and also it doesn't tell you what actions. He could be looking inside of the windows and they could just assume that he's breaking in. We don't know. The DIMS does not state.
yeah, no, I think that it's enough. I mean, it's such a low standard for probable cause. We have someone who's allegedly trying to break in. You know, they tell him to go away, and then I'm gonna come up, or I'm gonna. I think that a reasonable person would be in fear. I would.
Not of imminent, serious bodily injury. He's making a future threat stating, I would, and that's conditional. I would come back and I would come back with a gun and kill the complainant. That's a future threat. It's not saying that he had weapons on him that can, you know, give rise to fear. And then as far as breaking in, it says one of the shops. Is it the shop that the complaining witness was in or not?
What, so give me the statement again.
yes, Judge. So the complainant advised the defendant, let me show this the right one, sorry, I actually scrolled up. This is, complainant advised the defendant who knows about the site, refusing to believe. Yeah, refusing to believe when he was asked to do so. Defendant made threats toward the complainant, stated he would return with a gun and kill the complainant. Complainant had a video showing the defendant on property making the threats and trying to break into one of the shops on the property. Complainant acquired the name of the defendant from a tenant who had done business with the defendant in the past. And then it goes into Fleischer.
Yeah, all right. I'll find no PC on that one, but I'm gonna find probable cause in the other one. Yeah.
Thank you, Judge.
Okay, so which one was the one I'm finding no PC on? Is that the first or second one?
It's 256-9484.
9-4, that's the no probable cause?
Yes, sir.
Okay. Okay, done.
Thank you, Judge.
Okay, yes, ma'am.
Good morning, Ms. Dunn. They're right there. Yeah.
All right, Rick, we'll get you out of here, man. Hey. Oh. Do you mind calling up, Addison? Yeah, so we can get them out of here. So they don't have to wait. Hi, are you ready?
Yes, sir.
Who,
Jose Bandera?
please?
Sorry.
Yeah. What, are we doing a plea or are we doing?
Please, sir.
Is there any restitution in the FSGI? Do you mind looking at that while we do this? Mr. Balderas, you're charged with 2 cases. You're charged with driving while intoxicated, which is elevated to a Class A misdemeanor because of the high blow. You're facing up to a year in jail and or a $4,000 fine. You're also charged with failure to stop and give information. And on that one, you're facing up to 6 months in jail. I'm assuming as a result of this plea, they're going to dismiss the second case.
I can't confirm with Sean, we didn't have that in. Oh, yeah, yes, Your Honor, we are dismissing.
I know, right, but is there restitution that's,
I do not see.
The chief checked with the insurance company, they're paying for it during negotiations, everything. And in case they didn't, it's an 18-month probation, and the defendant said, hey, go take care of it.
but the problem is like, I don't think I can add it on after the fact. You either get it done now or you don't do it at all. That's why I'm inquiring. But you're saying he had insurance?
Yes, and they're
Okay.
They're settling everything.
Got it.
Everything's getting done.
Mr. Balderas, the agreement that you have worked out is 1 year in Harris County Jail to be probated for 18 months. As part of this probation, is this a true first or is it a second?
Checking right now, Your Honor. It's a true first, Your Honor.
Yes.
True first? Okay. You've worked out a 1 year Harris County Jail sentence, but I will probate that for 18 months. As part of this agreement, you must fulfill several things to stay out of jail. You must do a effective decision-making class. You must do an DWI education class. You must do 1 victim impact panel. You must have and maintain a guardian interlock throughout the entire time. You may not refuse a breath test while you're on this probation. If you were pulled over, an officer asks you to submit a breath test while you're on this probation, you must do it. You are not allowed to consume alcohol or illegal drugs. You must perform 10 hours of community service. These are all the conditions that you must fulfill to stay out of jail. If you violate any of these conditions, and I don't care what your excuse is, I will issue a warrant for your arrest. We will have a hearing to determine if you violated this condition or that condition or whatever condition may be. If you violate, you were looking at 1 year in jail. Do you understand?
Yes, sir.
I don't care what your excuse is for the alcohol. No alcohol means no alcohol from any source. I don't care if it's NyQuil. I don't care if it's mouthwash. You use, you go to jail. Do you understand? You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you enter into this agreement, you sign a contract with us indicating you will complete these conditions. If you do not, I've already told you, we will issue a warrant, put you in jail, then have a hearing to determine if you violated this agreement. Do you understand?
Yes, sir.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance. If you do not have a license, then you're not allowed to drive and you must maintain a portable device. Do you see if he has a license?
I have no license. No license.
You are not allowed to drive. I do not care what you have to do in this life. Do not drive. You will be signing an affidavit promising us you're not going to drive, Mr. Valderas. Do you understand?
Yes, sir.
How do you plead to this offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to follow this agreement. I will sentence you to it. So did you say license or no license?
No.
No license. Okay, so, all right. Best of luck to you, sir. Thank you, Mr. Isaguirre. Yes, yeah, right now. Coming up, Mr. Addison. Okay. Are you ready, counsel?
Yes.
Come on up. Right here. He needs to sign the order for protection. Hey, good morning.
It's a first go.
Right. Miss Stone, you are charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement. They're offering you 3 days in jail with credit for the 4 days that you've done. You need to understand that this charge will go in your record. It will be there forever. From now on, you're facing a minimum of 90 days in jail. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I'm going to follow the agreement. We will roll your court costs so you won't owe anything. Good luck to you, man. All right. Thank you, Mr. Beaton.
Thank you. What's up over here, Ms. Stone?
Hey, Judge,
Hey, yeah.
Hi, Judge, approaching on a plea for client Lawton, LAWTON. Timothy Lawton. Both? All right, thank you so much.
It's a lot.
Yes.
Okay.
And other two persons are getting dismissed. Oh, thank you.
Good morning, Mr. Lawton. So you're charged with driving while intoxicated. You're facing up to a year in jail and or a $4,000 fine. You've worked out an agreement. They're offering you 3 days in jail with credit for the 4 days you should be done. This charge will go on your record. It will be there for the rest of your life. You get pulled over, officers will see this DWI. If they smell alcohol or if they smell weed in the car, what do you think is going to happen? Probably nothing good. What we're doing today, it's a minimum of 90 days in jail from now on. Do you understand? There are no more proverbial slaps on the wrist. So if you act like a child and do things like a child, it's just not going to end well for you. Think before you act. It's not hard. I would take an Uber from now on because if you get pulled over and you smell anything funky, it's probably not going to go your way. You understand, sir?
I understand.
You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. So on this case, we have a reckless driving, we've got a DWI, we've got a gun case. Are the gun case and the reckless being dismissed?
Yes, Judge.
Okay, and then what about the weapon that's being forfeited?
It's not something we discussed, so I intended not to be forfeited.
Well, I'd like to talk about it if, I mean, what do you guys want? We need to know.
Target local, I think.
Law.
Okay, then whatever.
We'd like to sit down and work out with you, Honor.
Judge, that was part of the plea deal. I mean, that's something we talk about in the plea deal.
Say it again?
That's something that's discussed in the plea deal. That wasn't part of the plea deal.
Well, that's why I'm trying to figure out what's going on because I don't know about giving the gun back with all these charges and then, I don't know. That's why you guys, so step back and talk and you guys figure it out. Let me know what you guys want to do.
Judge, we'll just forfeit it.
Okay. That when you get pulled over, officers look at your record. These are things that they look at. People with records tend to get looked at more closely. You know what I mean? That's why you don't want to give anyone more ammo to use against you. It's not hard. This life is not hard. It's just you think before you act, especially considering, you know what I mean? All right. How do you plead to these? How do you plead to the DWI? Guilty or not guilty? I'm going to find you guilty. I'm going to follow the agreement. I'm going to suspend your license for the minimum, which is 90 days. Do not drive until you get a license. I'm now going to waive around $6,000, $6,500 of fines and fees for you. But you don't get to keep having rewards when you pick up criminal cases. You pick up a second DWI, it's now a minimum of 90 days in jail and a second conviction. It's a $6,000 surcharge. And if you don't pay it, every $100 that you owe, you sit 1 day in jail. You understand? Take an Uber from now on. Good luck to you, Ms. Love.
Thank you, Judge. Appreciate it.
All right.
These are over here, so not more.
Hey, did you file the knowledge yet?
Yes, I did, but I didn't refuse to
Okay.
refile the
Got it.
Yes,
They're detailed.
Got it.
They're
Okay.
with the right.
Do you want me to sign this?
Yes, it's not generating in the system. It's not.
Got it. Okay.
And that is the same for Mr. Lawton.
Yes, yeah. Oh, wait, I think I gave you the wrong one. No,
This is great.
I gave you, we haven't done that one.
Yeah, the one that was wanted. I mean, I told you, you can just form, and you have some back to collection, so that you want to. It's not. Just make sure you stop it before you, so we'll put your keys. Does that have work for you?
Do me a favor. It says unopposed motion for return. I don't sign it unless someone comes up and talks, especially given the fact that I don't even know if the gun is that dude's gun. I need some proof.
Okay, sure.
Please.
Only good
Right.
is that's a good piece of work. I'm pretty sure you did. For this last case, law was the 90-day license inspection. Yeah, okay, cool. On 17, if council approach on that one, defendant can. Still, she's still here.
No,
That's okay.
Top of 19, required parent per review. That was up here.
Okay, 5,001. Have you talked to Abel?
Yeah, he said he was supposed to be here.
Okay.
Top of 26, the required parent that was over here. And then
5,002.
That's it. Bottom of one is working on the building. And then Alan is working on a plea in the holdover for page 38.
Oh, is that one dude?
Thompson, another woman.
Okay.
Amiga Thompson. Oh, I just want to make sure I have.
Brandon, you ready? Are you ready?
I just finished the paper.
Yeah, so I'll forward it to the other guy. But it's in the, oh, yeah, oh, yeah. Oh, what's your name? No, I was supposed to be. Just there's really fast. Yeah, there's a way to.
Miss Aguirre, come on. Are you guys ready, Miss Aguirre?
Just see the number. Yeah.
Yeah, just both.
Over here, I'm saying, you write something on the book.
Okay today, Judge?
Yeah, Brand, how about you? Anything good?
Running around like a chicken with my head cut off.
That's good. Really,
Means that
it is good. That's right. Miss Aguirre, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement where they're offering you 3 days in jail with the credit that you have. You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. This DWI will go on your record. What we're doing today, from now on, it is a minimum of 30 days in jail. There are no more proverbial slaps on the wrist. Do you understand? The next time you get pulled over, and it's going to happen, an officer will see this DWI. If they smell alcohol or dope, what's going to happen? Very possible. You never know what's going to happen in this life. But if you do have a prior DWI and you smell like alcohol, you understand. Life is not hard when you do the right thing. If you want to drink, if you want to go get lit till your heart's going to take an Uber, it's not hard. And it's $20 freaking no matter where you go. How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I will sentence you to this agreement. I am going to suspend your license for 180 days. Do not drive until you get a license. Do you understand? If you do, you will be back here and it's not going to go well for you. All right. Good luck. See the clerk. CC.
If she has any credit for her license?
No. She has her second bond violation. She's lucky she's even.
Yes, sir. Understood. Can we wait? Yes.
Yeah, that I will do.
Thank you.
Yes, absolutely.
Maybe-
Are you ready? Yes, sir.
Good morning.
Hey, good morning. Is this your clerk? Do we need her? Do we need her? Something?
Yes.
Ma'am, we need your thumbprint real quick, if you don't mind.
Page 38.
Thank you.
Give me a second.
What a day.
On the presentation. I got it. Thank you.
Does this take care of upstairs as well? Okay. You know, there are not many times in life that you get to plead to a misdemeanor and they're going to dismiss a accompanying felony. You're extremely lucky, and I would take that into consideration next time you get into a car. With your criminal history, when you get pulled over, what do you think officers are going to do? Every single time. Miss Thompson, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 22, and 23 priors. Every time you get pulled over. Do you understand? If you smell like alcohol, if you smell like dope, all you do is you are giving them reason. Life is not hard if you do things the right way. If you want to get lit, drink 52 beers, 32 shots of tequila, don't get into a car. Do you understand? Really, an Uber, $20. It's a geographical oddity. Anywhere you want to go in this life, it's $20 in an Uber. Really. You want to go to Paris, Texas? $20. Really. It's not hard. The agreement that you have worked out is they've offered you 141 days in jail with the credit that you have. As part of this plea bargain agreement, like I said, they're going to dismiss the felony upstairs. You were giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, you were stuck with us and forever. Do you understand? I do see that you have a prior DWI. I don't know what happened on that other one, but a third DWI, you're looking at yet another felony, a third-degree felony to attend at the penitentiary. Do you understand? How do you plead to the offense, guilty or not guilty? I'm going to find you guilty. How much credit is Ms. Thompson?
I'm sorry, no, 141.
I was going to say.
I thought this was.
Okay, so I am going to give you credit for the time that you have. You're going to be getting out today, barring no holds. I don't know, but just really, it's not hard. Just keep our streets safe. Good luck, man. Oh, 1 year license suspension.
Yes.
All right, good luck, man.
Thank you.
All right, thanks, Al. Counsel, you ready?
I am.
Hi, Mr. Smith.
Good morning, Judge.
How are you?
I'm doing well. We're trying to be proactive because Mr. Salazar bonded out.
Okay.
He's getting conflicting messages with his license. We want to make sure it's very clear.
Just same conditions continue. Yeah.
Thank you very
All
much,
right.
Judge. Have a good day.
Take care. You too. Hi.
Hi, Judge, approaching again for.
Sure, I remember. Yeah.
Okay, so her father will not allow her to be there, unfortunately. So. What condition is it?
I'm not, I mean, she's in custody. There's no conditions to place on her at this time. If she does bond out, if you find someone else, let me know. And then we'll work on, giving her a PR bond with a GPS monitor. But the last thing I want is her to just go on the streets and then something worse happen. Work with the DA's office. Perhaps you guys can do, like some kind of reentry program or whatnot. I don't know, but maybe, find if there's someone else, sister, brother, cousin, anyone else, and then just let me know. It's now noon, so I mean, we can roll to tomorrow, Friday. You tell me.
Okay.
I'm at your mercy, whatever.
Can we get another date and,
Yeah, whatever you want.
yeah,
Just tell Victoria, we'll give you whatever you want.
Sounds good.
Yeah, it doesn't
Thank you so
matter.
much, Judge.
Yeah, if you want a day, a week, a weekday, whatever.
Let's take a week. She has a few
Sure.
siblings. I want to be able to call her.
Okay, sure thing. Just let me know.
Okay.
And if you know before the next court date, come earlier. Doesn't matter.
All right. Thank you, Judge.
Okay, yes, ma'am.
Wait a minute.
Alan, what's up?
Mr.
Just the last name,
Johnson.
Johnson. Jail or bond?
Okay.
Okay.
Not requesting a reset in this case?
Is he here?
He's here.
Got it. Okay. Do you have him?
I need to go speak to the state with chief about the case. That's all. So rather than hold up the course now with them.
Sure, but you're at 170 days, right? So I'll give you up to 2 weeks. At the next setting, they got to be here. Discovery complete.
Your Honor, you have an offer in.
You have an offering? Okay, we'll give you a couple weeks, but they got to be here ready to do something. Okay, all right. Have fun.
Or if I'm still using a 911.
That's not good. No. We're missing, we're, you had 170 days, you're still missing evidence. That's no bueno. So you got 10 days. We'll do a 10-day discovery hearing. Okay, all right now.
I've been here.
We did, yes. Just want to confirm the reset date. It's in the computer, is that accurate? On Mr. Sanders' one.
You want, 4:15, that's what you had originally.
Let's see, that should work. Wait, that's not the next.
You can change it.
We could, what about the day on the 16th? Is that okay?
Well, it's still really young, so we can push it out to the first week of May, like, how's May 5 through the 7th?
Can you be May 7th, please?
Yes. Do you want to call them up this
Yeah,
time?
yes. May 7th is absolutely.
We're gonna try to just send
Veronica, were you done with Salazar? Yes. Oh, so go ahead and sign for your receipt. 10 days. April 8th. Yes, we'll print it out and then we'll.
Okay, thank you. Yes, nothing like this.
Hey, great. Yeah,
Good morning.
just the last name of your client, please.
Yes, sir. It is Leonidas.
Thank you very much. Have a good.
Leonidas.
First name Brenda. The first appearance, Your Honor, I was like, to see if you can see her. I don't think I'm officially attached yet, and I'll get the attorney record file.
Let's do that first.
Okay.
Please, if you don't mind. I probably have one there. We'll attach you now and then we can get it done.
Yes.
Hey, if you come again in shorts, I'm gonna put you out. This is a courtroom. What's the last name?
Johnson.
Alan, would you please admonish your client?
Yes, sir.
Judge, our last one is on 17, bottom of 17. Mayfield, I think we left also, because she did tell the deputies, my attorney said my case is like, for tomorrow, but I had never.
5001. You can't just leave. Okay, are we done?
May I approach?
Oh,
Just on this.
yes, come on, please.
Sorry, I didn't get that. It takes too long. Just trying to review the evidence in the case.
Okay, ready?
Yes, Judge. Sorry.
Go for it.
So on March 18th, 2026, in Harris County, officer conducted a traffic stop on a vehicle going 64 and a 50 on the K freeway. The driver was identified as.
Hold on, 64 and a 50?
Yes, Judge.
Okay.
So defendant was identified as the driver. Officer observed droopy, red, bloodshot, glassy eyes, and slurred speech. The defendant stated she consumed 2 whiskeys at a party, refused SFSTs. DIC was read, and the defendant provided a breath sample with the results of 0.174 and 0.183.
Yeah, that's. Yeah, just.
Okay.
Okay. What I'd like to say, Your Honor, is that first of all, speeding is not a sign of intoxication, so that's not a consideration in terms of whether or not there's probable cause here.
Well, but they use the odor of alcohol, they use the droopy eyelids just to begin the DWI investigation, and then they use the field sobriety test to justify the arrest, right?
Correct, typically. But I don't think just the mere refusal to perform field sobriety tests is enough for an arrest. The investigation here took 3 minutes or less. It's a super cursory investigation. He gets her out of the vehicle, he doesn't, she gets out of the vehicle perfect. She steps out perfectly, she doesn't misstep, she doesn't do anything.
How do I know that?
I understand, you're just walking the 4 corners. of the- I understand, I get it. I understand the point at which we're.
I mean,
Sure, and I get it. You're just walking the
and
4
then
corners.
by your logic, we would never have a DWI, ever. Imagine.
Sometimes.
No, because if I held that theory, we would never, because everybody would just, no, I don't want to do it. And then you literally have proverbial floodgates.
Sure. What my point is here, though, I guess, Your Honor, is that the investigation is so perfunctory that, he doesn't get her out and speak to her and try to ask her more questions or talk to her at all. I mean, he just asks her 2 questions and gets her out of the car and immediately puts her in handcuffs.
And that may be so, but that's for a jury to decide. For probable cause purposes, is there a valid stop, right? Or is it just for s and giggles, right?
Sure.
Is there a valid stop?
Within the
Is
four
there,
corners.
is there any indicia of intoxication? Usually with the bloodshot eyes, slurred speech, odor of alcohol, any other indicators, slumped over, sleeping, urinated on themselves, vomit everywhere. And then that as the cursor to begin the DWI investigation. If someone refuses it, then they refuse it, right?
Right.
But I can't not find probable cause just because they refuse it.
Sure, I get it. And I get that we're probably trying to put the cart a little in front of the horse here, and I understand. What I will say is my client is a native Spanish speaker and speaks with kind of a thick accent. And I've reviewed the videos and watched, and I know we're not getting into that yet. We're in the 4 corners of the day.
It wouldn't be fair to them.
Sure. Anyway, I guess we'll get there down the road.
Right. And you may be very well right and so, and that may be for a motion to suppress. It may be for trial, but those are right arguments for a jury to see and go, yeah, you know what? He's right. This officer just shot first and asked questions later. I don't know. Is that her right there?
Yeah, sure.
I think I've already done bond conditions on her,
Yes.
correct?
Yes,
Right.
you did.
You guys are free to go.
Okay, thank you.
Okay, for sure. Good try.
I think
But
there's
that's-
there, but I just think you're right. We're probably.
Set up for a motion to press. I'm happy to do it,
I just
Really?
don't do pre-trial ones just because it ties my clients up in appeals for the next
Yeah.
3 years. Thank you, Judge.
Of course. All right, with that, we're
That's
done.
all I need from you.